Your days have been full of creative sparks and cool new friends. I am Kelsey Polstowait. I am one of Debbie's students in her branding program that she mentioned introducing the afternoon keynote. And I am working on a 100-day project if you would like to tell me about your shoes. But this is not about me, this is about Katie Lane. So Katie Lane is an attorney and a negotiation coach who works with artists and freelancers. Katie is proudest of the fact that through her work and her speaking engagements like this one, hundreds and maybe even thousands of designers, contractors, cartoonists, authors, and other creatives feel more confident handling the contracts and negotiations that come up in their careers. In her own words, "I'm not sure if there is anything more rewarding than hearing from someone that they had the confidence to stick up for themselves and demand what they needed because of something that I taught them." Fun fact, Katie also recently began sewing. She's also a writer and a forever student. The results of both her learning and written works can be found on her blog, workmadeforhire.net, but for more information about her sewing, like the progress on the button-down shirt that she's currently working on, you'll have to ask her for yourself. So, what is Katie most excited about? In her own words, "I'm excited about the chance to teach designers how to understand the difference between inspiration and infringement, because I think it can be an intimidating topic, and I know that there's a lot of unhelpful advice out there. I'm also excited to reconnect with speakers and attendees from past How Design Lives and to meet new people I can look forward to seeing next year." So without further hesitation, please join me in giving Katie Lane the warmest of welcomes to the stage. Thank you.
We definitely need to talk about these shoes afterwards because I'm very proud of these shoes. So this is me. I'm Katie. I am a lawyer and a negotiation coach, but I promise I'm gonna make this as fun and as accessible as possible. If you would like to find me online, this is where I live. If anything I say today you find particularly helpful or insightful, or it helped you make the connection as to how copyright works, my request is that you share it. Share it with other people. I call myself an evangelical for legal literacy. I want creators to understand their legal rights and to understand how to operate their careers and their businesses. So you don't have to tag me, but please just share it with the How Lives hashtag or Design Law, because that is one that people use. Confession, before we get too deep into things, I am a lawyer. Lawyers aren't well known for their presentation skills. So I make these promises to you. I'll only use Futura. I'm not going to use any other fonts. That's all I did. Nothing will spin or blow up during the presentation. There are no special effects to make you feel like this is more interesting than it actually is. And there will be no bullet points in teeny tiny type that you can't see from where you are. I'm going to ask you to keep questions until the end, just because I want to make sure I get through all of the information that I have. But if I have delved into lawyer speak to a point where it is no longer understandable to you, if you could just wave your hand in the air, that'll be a good visual cue for me to know that I haven't explained myself as well as I thought I had. And since the whole point of this presentation is to help you understand things, I want to be understandable. So that would be a very helpful thing for me if you would be willing to do that. So why talk about inspiration and infringement? I've told a couple people that I have avoided this topic for a long time because it's really complicated. But I am also really, really tired of signing onto social media and seeing things like this. This is an example I found back in early April. On the left there is a piece of artwork by Shannon O'Neill. She's a fabric artist, and she had created this piece back in January 2015, and then found out that in the 2017 collection, Lazy Oaf was releasing a pair of overalls with the stitching on it, as well as a couple other things that looked a lot more similar to the thing that she had created. And what made it even worse was that when she approached them, they said, "Oh, we had that picture on our mood board. while we were designing our collection. We just thought it was vintage and didn't go looking for it. Are you kidding me? Like, basically, one thing for you to know is that laziness is not an actual legal defense to copyright infringement. So nobody is going to give you props for not doing a reverse image search. And to the degree that you're worried about it, if somebody uses your work, they're not going to be able to get out of it by just saying, oh no, I found a picture on the internet and I really liked it, so I used it. Shannon's Etsy store, if you want to go and actually buy the real thing, is oddlyweird.etsy.com. But so this bothers me. I know that I'm not going to be able to stop infringement, right? Like, that's just going to happen. People steal, people are jerks. I can't interrupt that process. But there is a process I can interrupt, and I really, really, really want to. And it is that inevitably when stuff like this happens, somebody will chime in and say, hey, I know the magic number about copyright infringement, and what's the difference between infringement and fair use? And so this person says, from what I understand, very little, so points for self-awareness, people are allowed to use any image as long as they modify it by at least 15%. Lazy Oaf effed themselves by using 4 eyelashes. Yeah, 2 would have been much better. The same color scheme and same exact expression. Their design patent image search should get a hit on your hard work. No, no, this is not how it works. There's no 15% rule. There's no reverse image search. This wouldn't be a patent design issue. It's copyright entirely. But then, so it's the internet, so people come along and they're very helpful. And they say, oh, no, that's not it. It's not 15, it's 30. By this point, my ears are bleeding, because 30% doesn't make sense either. Like, I want you to remember that lawyers come up with legal rules. Do you think that we understand what 30% of an image is? Or 30% of a painting? Do you want that to be the rule? Because we have to apply it, not artists. Lawyers. So that's also not true. But then luckily, my clients are on the internet too. And so Emmy came on and she said, the 30% thing is not a thing. It's super not a thing. And so Emmy made me happy, because this is true. There is not a really easy, practical rule that you can use and say, well, I flipped the image and I changed one of the colors, or I changed the expression, so that's fine. And I know that as designers, you're not interested in stealing somebody's work. Like, that's not your goal when you sit down and work. But that you're influenced by a lot of things, and so the idea that you could possibly accidentally infringe somebody else's copyright is intimidating. I also know that it's really intimidating to think that somebody else could steal your artwork really easily. And so I'm not going to give you any quick and easy rules, and for that, I am sorry. But what I can do is give you some practical guidelines that you can follow, so that when you are making creative decisions in your work, you are making inspirational choices, rather than choices that come from infringement. The other thing that I hope these practical guidelines help you with is being able to identify when somebody has actually misused your work, as opposed to been inspired by your work. In order to do that, though, we need a little crash course in copyright law, and I'm going to be as gentle as I possibly can. I am a huge nerd for this stuff, literally, but I know you're not, so I'm going to try to be as gentle and kind as possible. So first up, copyright protects certain types of work, and those types of work have to have 3 qualities. The first is that they are original works. They must be fixed in a tangible medium, and that just means I can reproduce the work. If I create it, you can see it. It is something that can be copied. And then it is expressive. It is not just a representation of an idea, it is expressive work. So the way that it's written in the Copyright Act is that it's an original work of, oh gosh, I just forgot it because I'm on stage. It's an original expression fixed in a tangible medium. And the 2 things that we're really going to focus on with this definition are the fact that the work is original and the fact that it is expressive. And so when we say original in copyright, what we mean is not a copy. That's literally how granular we are. We just mean that you have not taken something that somebody else made and made a literal copy of it. The other way that the Supreme Court has helpfully defined it is that an original work is one that shows a modicum of creativity. So the bar is pretty low. The court case that this came from was about a phone book. Somebody had driven around town and collected all the addresses and the phone numbers and put them together with people's names and organized them, and then they tried to copyright that information. And the court said, good work, you worked real hard, but there's not a whole lot of originality in what you've done. You basically just created an alphabetized list. So hard work is not the defining issue when it comes to copyright. Excuse me, we're looking at how original the work is. And the other thing is that copyright is going to protect the expression, not the idea itself. And the reason we don't want copyright to protect ideas is because copyright lasts a really long time. So right now, if I create something, an original work, fixed in a tangible medium of expression, the copyright on that work is my entire life plus an additional 70 years. Imagine if I were the first person to paint a sunset, because I'm very original in my ideas. But if I were the first person to paint a sunset, and the copyright gave me the ability to protect the idea of sunsets, that means I could stop other people from painting sunsets, or taking photos of sunsets, or using sunsets in movies. And I think we could all agree that that would be dumb. Not because sunsets are so fundamentally important to our democracy, but because my way of expressing that idea is likely not the only way of expressing it, and might not be even the best way of expressing it. We want people to use ideas. As a result of the fact that copyright does not protect ideas, there are certain things that just don't get protection, that people often think are protectable. Titles, I get a lot of people asking me if I can copyright a title of a book. No, I cannot do that thing. Short phrases or slogans, again, that's not something that copyright is going to protect because copyright wants to keep ideas available to others. It does not want to prohibit other people from using those ideas, but what it wants to do is protect expression. And then the one that always bothers designers is that typefaces don't get copyright protection. The software that renders the font will get protection, the code gets protection, but the typeface itself is not getting protection. And then artistic style. I see a lot of artists online sometimes get upset that their style was copied or their style was mimicked. And while that is maybe frustrating and disappointing, it is not copyright infringement. So what is copyright infringement? Well, it is when a copyrighted work is reproduced, distributed, performed, publicly displayed, or made into a derivative work without the permission of the copyright owner. So it's one of those 5 actions, and the 2 that are going to be most important to our talk today are when a copyrighted work is reproduced without permission of the copyright owner, and when it's made into a derivative work. What's a derivative work? A derivative work is when you take an original work and you create something else out of it. So my most common example is if there's a novel and they make a movie based on that novel. The movie is a derivative work of the novel. The movie needs the novel as its basis. It might be different from the novel. They might make it worse. But it is based on the original expression that was in the novel. So that was the crash course. How is everybody doing? Okay? All right. Yeah, good. Okay. So we're going to do a quick pop quiz. We're going to go back to our original example, Shannon O'Neill's fuzzy dog. Shall we call it a fuzzy dog? I don't actually know. I don't know Shannon. Is Shannon's work original? Yes, it is. It meets our modicum of creativity, not a copy. And I would say, like, some of the elements that you see in the work are pretty common, but together they make a original work. So, like, I wouldn't say that you can't have that shaped nose Like, she's not getting protection of that shape of a nose for a dog, but together, all of these elements constitute originality. Is this expressive, or is it just representative of the idea of a dog? It's expressive, because you could still create a dog that looks differently from this, correct? Yeah, so it is expressive. Do we think that Lazy Oaf's example is a copy or a derivative of her work? This is the hard one. Yeah, I think that there is enough there, and you know I made fun of it earlier, but honestly, those eyelashes, I mean, are you fucking kidding me? They are, excuse me, I swore, God. I've never done that before, just not on camera. They are almost the exact same length. They're going in the same direction. We've got the same color scheme. If you look at the reflection in the eye, it's in the same place. Like, come on. So, infringement. Maybe. Probably. And this is where it gets hard, because again, these are lawyers making up rules, and we don't want to make rules that are going to limit things too much, and so we came up with fair use, which I love fair use. I love fair use because it protects free speech. It allows other people to say things about work that they like or they don't like. It allows people to teach work. That's important. Fair use is really important to our democracy, especially right now. So I don't want anybody leaving here thinking that I have anything against it. I just want to make sure that it's used properly. So lawyers like tests, and the test that they came up with for fair use is what we call a balancing test. That means that none of the 4 factors are definitive. That means that we have to look at all of them on balance and decide whether or not something is more likely an infringement or more likely fair use. So the 4 factors, I'm going to list them, and then I want to talk about them a little bit. The nature of the use. And when we're talking about nature of the use, we're talking about the nature of, in the last example, Lazy Oaf's use. How did they use the original work? The nature of the original work. What kind of work was Shannon's work? What is the portion of the original work that was used in Lazy Oaf's work? How much of it? How essential to the original work was it? And then what was the impact on the demand or value of the original work? I know you're taking pictures, it's great. My next slide's so much better. So when we're talking about nature of the work, we're talking about, did they use it for a productive, holistic purpose, or did they use it for a commercial purpose? Are they helping other people? Are they commenting on it? Are they teaching it? Is it non-commercial in some way? Is it criticism? Those are all good things that we want to encourage, whereas crass commercialism, believe it or not, is not something that we want to encourage. When we're talking about the nature of the original work, is it fact or fiction? If I write a history textbook, I have a copyright in my textbook, and that's important, even though most of what I'm talking about is factual. But because it's factual, I can't protect, and that's when you all yell, the ideas. So I can't protect those facts. I can't protect those facts, right? Because I want you to use them. So when I created the thing, I expected that you were going to quote portions of it, that you might reprint portions of it somewhere else. I expected you to use it. When we're looking at the portion of the original work used, did you just use small portions of the work? Just only the bare amount that you had to in order to make your point? Or did you use the most important, the heart of the work? So the court case that this comes from involved the Supreme Court, and I love this so much, sitting in chambers listening to 2 Live Crew. And they had to decide if the sampling from a Roy Orbison song, Pretty Woman, was copyright infringement or fair use. And they looked at it and they said, you know what, they used a small portion of Roy Orbison's original song, but it's the essential part of it. It's the part that's most recognizable. And then impact on demand for the work or the value of the original work. Are people going to buy the copy rather than the original? Does the copy replace the original? Would the artist have gotten money for the licensing? The tricky bit about that, though, is if you haven't licensed your work before, the court's not going to consider you having lost licensing fees, because the court's going to say, well, you're not really doing it, so the fact that you didn't get it this time doesn't mean that you lost income necessarily. So now that we know the test, let's look at this again. We think it's probably infringement, which fair use is a defense to infringement. So there's copyright infringement, and then we ask ourselves, but is it fair? Is it okay under the law? So the first one is, what is the nature of the use? What do we think? Yeah, it's commercial. They're there to make money. How about the nature of the original? Is it a creative work? Is it a commercial work? I think it's a creative work. Yes, she's selling it, but the point of this was it was to create something. It was not factual. There shouldn't have been the expectation that other people were going to copy this and create other things. I think there's a substantial use argument. I think if there had been just one element or two elements, we might have a different argument, but I think there's substantial use. And then I do think that there's a lot of an income argument here, especially because some of the other things that Lazy Oaf was selling were handbags, and this was originally a handbag. So in this case, I think the balance is that we have a valid infringement claim. What happens in court, I have no idea, because court is weird. But here in this room, I think we have a valid infringement claim. Okay, so that practical guideline number one is don't copy. Helpful, right? Aren't you glad you came? Don't make exact copies of things. If you're going to make an exact copy of things, make sure that's not the only thing in what you have created. You want to be original in your work. You can be influenced. You can use reference. That's great. That's what I want you to do. But don't copy. OK, next one. This is from my friend David Malky's comic. He does a comic called Wondermark. By the way, I want to point out, Mr. Malky requires an exclamation point after his name, exactly one space. So Wondermark, David's got this great collection of old books with etchings in them. They're all in the public domain. So he'll take them, reproduce those images, and then create comics out of them. Oftentimes he's adding an element or two to make the joke make sense. But essentially, he is reusing things. It's a very funny comic. I like it a lot. You should check it out. This is a comic by somebody named Dave Sim, who's a very famous comics creator. And Dave Sim was injured at some point in time. Excuse me while I drink. And he couldn't draw. But he read a lot of comics, and he read Wondermark, and he loved it. He thought it was hilarious. So he decided to make his own. And he gave an interview where he said exactly this thing. I loved Wondermark. I thought it was really funny, so I decided to copy it. And so he created Cerebus, which has Dante's Inferno. So again, those images in the background are all public domain. He adds the character up front, and he writes the comic. He writes the jokes. So we have, in this situation, an admission that, oh yeah, I read that thing. I liked it a lot. I made my own. Is David's work, they're both named David, that's not helpful. Is Malky's work, is Wondermark original? Yes. It meets our modicum of creativity. It's not an exact copy. To the degree that it is reusing things, those things are no longer under copyright protection. Is Wondermark expressive? Yeah, totally is. You could have this same idea and execute it differently. Is Dave Sim's Cerebus a copy or derivative work? I think the best argument for it is that it's derivative. I think this one is kind of on the line. It looks to me a little bit like Sim is playing with the idea behind Wondermark rather than the expression. But I think you could make an argument that it's kind of derivative. He even said, I liked your thing, so I made my own. So let's say that it is copyright infringement, and we get to fair use. And we're going to do our balancing test. What is the nature of the use? Commercial or non-commercial? It's commercial. He's done, because he does so little, he's done a lot of these. There are a lot of books. He's sold a ton of them. Cerebus books. So it's a commercial use. What is the nature of the original work? It's commercial, but it's creative. It's not a factual work. It is fictional. I don't think that there's significant use, though, from Wondermark to Cerebus. We're looking at different images in the background. The writing itself is very different. He's not repeating the same jokes. The characters that he's added, the drawings that he's added to Cerebus are different from anything that appears in Wondermark. And then, so no significant use. And then, what do we think the impact is on, do you think somebody would buy Cerebus instead of Wondermark? I don't either. And for what it's worth, David Malky doesn't think that somebody would either. So I don't think that there's a lot of harm, potential harm, in what Dave Sim has done. And so on balance, I think this is a fair use. So now you understand why there are no crystal clear, easy answers, right? It is a balancing act. We have to go through each of these questions one by one. And so my practical guideline number 2 is, if you've got a copy, copy the idea. Because the idea isn't protected by copyright. So the idea is free for you to copy. The idea is there for you to copy. You want to find a different expression of this idea. That is how democracy goes. And we want democracy to go for a very, very long time. Come on. OK, here's another example, another friend. On the left-hand side is Miles Davis's Kind of Blue. This particular photograph was by a gentleman named Jay Mazel. Over here on the right is cover art for Andy Baio's Kind of Bloop, which was a chiptune tribute, 5 times fast, to Davis's album. It was released on the 50th anniversary. Andy was working for Kickstarter. This was at the very beginning of Kickstarter, and he raised money to produce this album through one of the very first fully funded Kickstarters. He raised a little over $8,500. But it was enough to press some CDs, to have artists create chiptune versions of all the songs, and, importantly, to get this cover art done. And then Andy got a cease and desist letter. Can you see why, maybe? Yeah. So let's do our balancing test again. What is the nature of Andy's use? It is commercial. He was getting people to pay him to make this, and he was giving them the CD in exchange. What is the nature of the original work? Is it factual? Or is it fictional? Is it creative? Is this the only way that we could ever see Davis? No. Photographs are real hard, guys. Photographs are real, real hard. But I would say that this is a creative work because the way that the subject is framed, the way that the lighting works, the composition, how it's developed, those are all creative choices. And they're not going to be the same. If you give 2 photographers a chance to shoot, they're not going to come up with the exact same image. So I would say that this is a creative work. How much of the original did Andy use? A lot of it. I love Andy a lot, and I've talked to him about this, so we're good. But I would also argue, putting on my lawyer hat, he only used as much as he had to make his point. He only used as much of the image as he had to put it in this different, to make a different statement about it. Because remember, in context, this is the cover art for an entire chiptunes album, which music has compulsory licensing, which is why we're not talking about the music part of it. So I would actually argue he could have used a lot more depending on how the pixelated image was rendered. Because this is a hand-drawn image. This is not run it through the computer and see what you get. Because it turns out when you do that, it looks like crap. So I would say that there's an argument for limited use. And how much of an impact do you think this had on the original photograph? The photographer's estate said, "You denied us this licensing fee, it was awful." They hadn't licensed it very often. They likely wouldn't have licensed it for this. I don't think anybody's going to buy Miles Davis's Kind of Blue, or I don't think anybody's going to buy Andy's CD instead of the original Davis one. So I think that the harm here is unlikely. But I think the thing that tips this is something that we haven't talked about yet, which is I think Andy's use of the photograph is transformative. And transformative, I think, is part of where we get the myth about how, like, change 15%, change 30%. When we're talking about transformative, though, we are talking about an expressive meaning or function that is different from the original. We're not talking about just how the thing looks. We're talking about what it says. And I think, Katie Lane's personal opinion, that Andy's use has a strong argument for transformative because I think it's a different expressive meaning. I think you have to understand it in context, and that might be what hurts it. But what it came down to is this is different, but is it transformative? And one of the other things that they ended up arguing about, so he got a cease and desist letter, which means he hired lawyers, they had lawyers, they argued a lot, they negotiated. And what they kept arguing over was whether or not this was transformative, because transformative can have a huge impact over whether or not something is inspirational rather than an infringement. They ended up settling out of court for $32,500. That is a lot of money, especially when you only raise $8,500 to produce it in the beginning. And Andy, one of the things that he says he gets a lot of emails from people who ask him, like, okay, I'm going to do this thing. Is it fair use? He's like, dude, there is no guarantee that what you're doing is fair use. And that is the unfortunate part of it, which is why I want to focus on practical guidelines. Because I don't think it's helpful for you to just go through it and say, well, the law says I should be able to do this. I think you need more than that. I think you need practical guidelines. One of the things that Andy negotiated in his settlement, which is a gift to all of us, and we should thank him for every day, is that he negotiated the right to write a long blog post about his experience and fair use law. It is still up on his blog. It is kind of screwed. I highly encourage you to check it out. It's very helpful. Because usually when there is a situation like this, it all happens out of court, so we never find out what the arguments were. We never find out why they settled. So my next piece of practical advice is transform what's being said, not just what's being seen. Yes, you're obviously going to change the way something looks, but make sure it's saying something different. Give it a new life. Make it yours in how it is communicating with your audience. So don't just focus on transformation of the visual. Focus on transformation of what is being communicated. Okay, anybody remember this? I would say here there is a very big transformation in what is being expressed. I think that there is a huge difference in what is expressed in Shepard Fairey's poster versus what was in the original Associated Press photo. I don't think anybody, well, I know other people could argue differently because lawyers, but if you want to look at what's transformative, transformative. Unfortunately, what happened is when he was originally sued, Fairey said, oh, no, I didn't copy that photo. I copied a different photo. But he didn't. He copied that photo. And somebody on Flickr took the photo from the Associated Press and the photo that Fairey was saying he had copied from, actually overlaid the Obama's face on it and noticed that the faces didn't quite line up. And because of this lie, it kind of tanked the copyright case. They ended up settling out of court. He actually got in trouble for lying to the court. So one of my other pieces of recommendation, I know reference is really important. I work with cartoonists primarily, and then designers. And so I know how important reference can be. But if you're, I think what happened in this particular situation was there was the lying, but the portion of the original work used ended up overwhelming the analysis. It ended up overwhelming the analysis so much that the arguments about transformative didn't come through. But my next practical guideline regarding reference is, when you're using it, use lots of it. Don't limit yourself to one photo. Try to have a lot of ideas that are informing what you're doing. That reduces the likelihood of you breaking our first rule, which is don't copy. So if you're using reference, use a lot of reference. It's your insurance policy. And then number 5, please don't lie. Pretty please. I think it's just a good idea in general, but I think it's a particularly good idea here. That doesn't mean you immediately admit, yes, I copied your thing entirely. I meant to do it. I liked it a lot, and I thought I could make money off of it. But don't lie. Don't lie if you end up working with an attorney. Don't lie to them. Don't lie to the court. So to go over it again, don't copy. If you got a copy the idea. That's what's copyable. Transform what's being said, not just what's being seen. When using reference, use lots of it. Influence the heck out of yourself. And then don't lie. These are my guidelines. I think they're pretty okay. Because the loudest voice in your work should be your own. It is the best voice to use. It is yours. That is why you do what you do. Nobody else can do what you do. Even another designer can't do exactly what you do. Your voice is important, and it should come through. Even if you are lending that voice to a client, it should be yours. So helping creators create is my jam. It's why I do what I do. I like making sure that people know the rules that they have to follow. I like making sure that the law doesn't get in the way of creativity. Because I don't know if you've noticed, but storytelling and art are kind of important to me. And I don't want you to not do something because you didn't understand the contract or because copyright law was too confusing. So what I've been doing recently, I've got a bunch of great posts on my blog, workmadeforhire.net, go there. But what I've been doing recently is putting together like small little courses that just come to your email box, and they teach you how to do things. So if you'd be interested in one of those, you can text the word create to 345345. And what will happen is you will get a 5-email course on how to read a contract. I give you some basic practical guidelines on what to look for, how to approach it. I'm not getting into the legally bits. I'm teaching you how to read it, because it's like anything else, right? There is a way of reading it. There is a way of recognizing what's important. So that is my gift to you. It'll also sign you up for my email list, so that's my gift to me. And now we've got a little bit of time, not a whole ton, but if there are questions, I'd love to answer them. There's a microphone behind the camera, and I'd ask you to use that because that ensures that the people watching the video could hear your question, and I'm not going to have to repeat myself.
Is satire part of copyright or only part of trademark?
Satire is part of copyright, and satire would fit into fair use. Part of what we would look at there is what is the nature of the use. Satire is usually seen as commentary and criticism, so it does fit in with copyright.
So mine's kind of a follow-up to that. I was going to do an illustration. I was going to base it on American Gothic, and when I did web research, some sites said that Grant Wood's wife never renewed or extended the coverage, but that the museum that's in play owned the copyright, but I could never find defining information, so I skipped it. But I'm just wondering if you could address something like that that feels like it's in public domain,
Yep.
but maybe isn't.
That's a really good question. I think it's in public domain too. I can't remember the exact year that it was made, so I can't say definitively. But one of the things I can tell you that happens with museums when they acquire a piece like that maybe has fallen into the public domain, what they'll do is they will take photographs of it and create posters, and they get a copyright in the poster. That is different, and that's okay, totally fine. But that is different from having copyright ownership in the painting, in the image. The thing that the museum gets to protect is their reproduction of the painting, not the painting entirely. That's not legal advice.
Yeah. So then the follow-up, I guess, is a caricature, two things. If a there's so many caricatures of that painting that it's ubiquitous. But the other question I have is, does it matter at all if it's for a nonprofit? Okay.
Maybe a little bit, probably, because we would look at the nature of the use, like what is it for? If the nonprofit is using it to raise funds, if the nonprofit is using it for education, that's better.
It was editorial illustration.
I can't give you
Dicey.
legal advice, but
Okay.
it sounds really cool.
Thanks.
Hi, can you explain trademark versus copyright
I can do my
versus
best.
people that start with trademark then copyright?
So copyright is protecting works of authorship, original, fixed in a tangible medium of expression. So we're usually talking about drawings, stories, films. Trademark, we're protecting phrases and images that are used to sell goods or services. In order for it to be a trademark, it must be used to sell a good or service, and the consuming public must associate that image or word or phrase with that particular good or service. So with trademark law, one of the things to remember is trademark law is originally there to protect consumers. We don't want consumers to be confused about where their favorite shoes come from. We want them to be able to see the logo on the side of the shoe and say, yes, those are the shoes I like. We don't want them to be tricked into buying other shoes because the mark was similar. So trademark is going to be about the images or words that are used to sell a product, that are used in association with a good or service. And copyright is really more about protecting stories and drawings. Sometimes there is some overlap. But then we get into the whole idea expression thing with copyright, and it gets a little bit hairy. That's my quick and dirty.
Well, that was awesome, because that was actually mostly what my question was. And I guess maybe to ask a follow-up question to that, would there be any specific situations you can think of where it would make sense for a designer to trademark a symbol? And I guess maybe it would help to explain kind of my thought process. Like hypothetically, if I were to design a symbol or some kind of mark for a political movement and I wanted to avoid that symbol being used for any specific purpose that's counter to that movement, would a trademark make sense there? Or is that even not something that a trademark would make sense for at all? Or
Potentially. But with trademark, we like to have there be a single source, right? Mm-hmm. So I'm going to come to this single source to acquire my good or service. I'm not, and if there are many places where I could acquire this good or service, I want to know for sure that they're all connected back to that single source. So with political movements, it's going to be hard, right? Because the service that you're providing is freedom, which really isn't really isn't a consumable good.
yeah, no.
But yeah, I would say that's going to be harder. And it's going to be harder with copyright, too, because then we're getting into the idea-expression dichotomy.
Okay, that makes sense. Perfect. Thank you.
Yeah. One more question.
Hello. How would you suggest handling a situation where, say you're a photographer and you have clients who take your images, re-edit them, and then post them online, handling that in maybe a friendly way instead of going a legal route with it?
So your question is, you're a photographer, and you have clients, and that's it. Because I feel like with all photographers, their clients misuse their work. Part of it is client education. It's making sure that your clients know upfront what they're getting and what they're not getting. And I think that you can convey that information. It doesn't necessarily have to be in a contract. I actually tell people it's helpful to have onboarding documents with your clients and say, hey, you're going to get these things. This is about the timeline that you should expect. It's all according to our contract, but here it is in normal person language. And just remember, you can use it for these things, but not these things. So I think doing some education up front, and then also coming up with a friendly, sort of canned email that says, hey, I saw that you posted that on Facebook. I'm so glad you love my photo. Just to remind you, that's not part of what you paid for. If you'd like to do that in the future, please come. We can set something up. And so that way, you're saying, You're expressing gratitude for what they've done. You're acknowledging that you saw it. They didn't get away with anything. You're not going to do anything just yet, but you're giving them information about how they can do it right if they want to do it again. And then you just send that out every Tuesday? I don't know. All right, so my time is up. I'm going to hang out for a little while, and I hope you have a good rest of your day. This has been a lot of fun. Thank you so much.